Yes.
Lordship, I beg to mention item number 4. I have taken consent from the other side. I have to obtain instruction, but the instruction is awaited, Lordship. May kindly be taken up on Wednesday, coming Wednesday, Lordship.
Wednesday.
Yes, Lordship. I have taken consent.
Okay. On the prayer of MS B. Sharma,
Lordship.
learned CG, let this matter be listed on Wednesday is what?
17.
17.
Much obliged.
So so as to enable her to obtain instruction.
May I please, Lordship? But 35, Lordship.
Hmm.
I am for the respondent number 1 and 2, Lordship. So kindly allow 3 weeks time to file our reply, Lordship. And for the income tax department.
On the prayer of Mr.
For the petitioner, may the interim be continued.
I am JP More, Lordship.
JP Moore,
Yes.
learned counsel for respondent number
1 and 2.
1 and 2. Let this matter be listed after 3 weeks. So as to enable him to file affidavit in opposition.
Yes.
Mr.
S. Barua on behalf of R.J. Das.
S. Barua, learned counsel appearing on behalf of Mr. R.J. Das, learned counsel for the petitioner is present. Interim order passed, earlier shall continue.
Obliged.
Lordship, I beg to mention item number 45 with the question of the other side. We have filed the Wakalatnama yesterday, and we pray for some time to file our reply.
45. 45.
It's 45. Appear on behalf of respondent 6 and 7.
Respondent number
6 and 7.
6 and
May the matter be taken up after vacation.
you want to file affidavit or what?
Reply, yes.
On the prayer of Mr.
S. Barua on behalf
S.
of Mr.
Barua,
R.J.
learned
Das.
counsel appearing on behalf of Mr. R.J. Das. Respondent is granted. For respondent number
6, 7.
6 and 7. Respondent is granted 3 weeks time to file affidavit notice.
File of the interim may be extended for the petition.
Mr.
A. Sandelia for the petitioner.
A. Sandilia, learned counsel for the petitioner is present. Interim order passed, earlier shall continue.
May it please, Lordship, I beg to mention for withdrawal of item number 3.
Item
Item number 3.
3.
Quickly, body to file afresh.
Mr.
Ahmed Shakir. Ahmed Shakir.
Ahmed Shakir,
Shakir.
learned counsel for the petitioner. Praise for submits that he has an instruction to withdraw this petition with a liberty to file a fresh. Yes, for fresh for withdrawal of the same.
Obliged.
You are there,
4 and 5.
Mr. N. Goswami, learned state counsel for respondent number 4 and 5 is present. Accordingly, writ petition stands closed on withdrawal with the liberty as read for. Yes.
Obliged.
My lord, with the consent of the other side, I beg to mention item number 27, receiving the instruction. We are preparing for affidavit, Lordship.
You have received the instruction. MS,
Respondent number,
your name, please. Your name?
Arbora on behalf of S. Dutta.
Mr. Arbora, learned counsel appearing on behalf of Mr. S. Datta, learned standing counsel, PNRD,
I am for the petitioner.
submits that she has, submits that an instruction has been received, which department would like to bring on record by an affidavit. Therefore, praise for listing of the matter after 3 weeks.
2 weeks.
Praise the Lord, list after 3 weeks. You are
I am
Mr.
for the petitioner, B. Deuri, Lordship.
Mr.
E. Deuri.
B. Deuri, learned counsel but petitioners is present.
May it please your Lordship. Lordship, I beg to mention item 41 of the daily list for adjournment. Lordship, I have consent from the other side. I am for the respondent, AIDC. I am appearing on behalf of Mr. S. Das. A. Tarafdar appearing on behalf of S. Das.
On the prayer of Mr.
A. Tarafdar.
A.
Tarafdar.
Tarabdar. Tafadar or Tarabdar?
Tarafdar, Lordship.
Tarabdar, learned counsel appearing on behalf of Mr.
S. Das.
S. Das,
Standing Counsel of AIDC.
learned counsel for the applicant. Praise for listing of the matter. What I said on the prayer. On the prayer.
It will be taken up after vacation.
List the matter after 4 weeks.
Deeply of Lordship.
May please, Lordship. Item number 49, my lord. I require to file additional affidavit, my lord. 1 week time may be granted, my lord.
49.
Yes.
A.K. Mandal.
additional affidavit I will file within one.
On the prayer of Mr.
HR Ahmed.
H.R. Ahmed, learned counsel for the petitioners, list this matter after 3 weeks.
Obliged, my lord.
Please, your lordship. Lordship, I beg to mention item number 23. Mr. H.K. Das, the senior counsel, he is leading me on this case. He has some personal difficulty today, lordship.
On the ground that Mr.
H.K. Das.
H.K. Das, learned counsel for petitioner has some personal difficulty. Mr. M.S.
B. Saikia, lordship.
B. Saikia, learned counsel appearing on his first press report. Listing of the matter after 3 weeks, prayer or list after 3 weeks.
Deeply obliged, lordship.
Next, Your Lordship, I beg to mention item number 5, 6, and 8. Your Lordship, my senior counsel is not
Five?
well for
Huh?
5, 6, and 8.
Last time also you have,
Yes,
why?
my senior is not well for a few days, so
Unnecessary, you have got it listed. 5,
6 and 8.
6 and 8, same order. On the ground that Mr. N.H. Majarbuya, learned counsel for the petition, is indisposed today, Mr.
R. Kneeling.
R. Kneeling, learned counsel appearing on insurance press for listing of the matter after 4 weeks. Rather list after 4 weeks.
That's all right.
Yes, does. Non appears to the petitioner on call. Mr. N. Goswami, learned counsel, but the learned state counsel is present. It is noticed that on 29/05/2026, when this matter was listed, the petitioner remains unrepresented. List after 3 weeks. On the next date, if the petitioner remains unrepresented, an appropriate order shall be passed. List after 3 weeks.
My lord, here the petitioner grievance is, my lord, that pursuant to their complaint, no inspection and inquiry was directed, my lord. So basically, with this, my lord, the grievance he had filed a petition. I have an instruction, my lord, that the register of the cooperative society by this order has directed the inspection on in regard to the complaint. So therefore, his grievance is redressed. my lord.
Lordship, on not only inspection but inquiry must also be done. 87 and 88, we have filed complaint for inquiry as well as inspection. 87 and 88 of the Act. They are setting for inspection. Inquiry has already started, Lordship. Notice has been issued. Subsequently, show cause notice has also been issued. Inquiry has also to be done, Lordship. Right now, we submitted for inspection only.
Inspection,
After inspection and inquiry.
Because
Inspect, my lord.
inquiry also must be done, Lordship.
it's okay. The report, they will submit report. It's let them do it. If they don't do it, only inspection and pass the orders. Close the matter, you come back.
Lordship.
You will close this matter.
Lordship, may keep it pending because this
No.
87 is also pending, Lordship.
Huh?
Lordship, may I submit?
It's all right. First,
may I
they will have
submit?
inspection,
Lordship,
and then if it is required, inquiry also be conducted.
Lordship, inquiry has already started, Lordship.
Yes, they'll continue that.
They are not.
See,
they are
inquiry
stating
is under section 87.
87.
This is inspection 88.
88. Inquiry has already been started,
It's
Lordship.
okay. They have started. They'll do it.
They are only
We'll provide that.
They are only submitting for inspection, Lordship.
Huh?
They are only stating for inspection, not inquiry. Because, Lordship, they have the powers.
We'll observe that. Needless to mention that this the inquiry which has already been initiated
Must be complete.
under section 87 and the inspections will be completed expeditiously.
In accordance with law, my lord.
Lord,
Heard Mr.
Ekakoti.
Ekakoti, learned counsel for the petitioner. By filing this writ petition, and also heard Mr. S.K. Talukdar, learned counsel for
Cooperation department.
standing counsel, learned standing counsel for cooperation
My
department.
lord. I'm for 1 month.
Next para. And as well as Mr. N. Goswami, learned state counsel for respondent number 1. By filing this writ petition, the petitioner has prayed for a direction to complete the inquiry under section 87 and inspection under section 88 of the Assam Cooperative Societies Act 2007 in respect of the affairs of Aria Smart Living Group Housing Cooperative Society Limited. List of having considered that the next para, having considered that the inquiry under section 87 of the said act has been initiated.
No, no,
Initiated.
I don't agree with my learned friend because his grievance is neither inquiry nor my lord inspection has been done. Now, what is contemplated under the act is pursuant to the inspection, my lord, if it is necessary, inquiry will be done. So the initiation, my lord, is by way of the inspection, my lord. How can my lord the card?
No, in that case, we will not say any.
Yes,
Having considered.
Lordship may come to page.
Yes, it's okay.
Lordship,
Page
57. 57 of the writ petition, Lordship. Subject, direction for production of records and written explanation. Enquiry under sections 87 and 88 of Assam Cooperative Society.
Yes, this is already been initiated.
If it's
Already initiated, Lord.
why he has again come, my lord, before this honorable court?
Therefore, what they are saying is that you have not completed it.
You have not completed.
You have just initiated
Yes,
on the
initiated.
complaint. That's
That
right.
is initiated.
Anyway,
On page
having considered that the inquiry has already been initiated by communication dated
11 August.
11/08/2024,
2025, Lordship.
2025,
My lord.
11/08/2025.
There is one aspect of the matter. Now, my lord, the board having been dissolved. The earlier.
It's
board-
okay.
No, lordship will kindly appreciate. Now a department
And-
officer,
and-
my lord, is engaged.
And
Earlier board is dissolved. So therefore, the inspection under 88 my lord,
the-
is commenced.
Learned Standing Council Cooperation Department was directed
This
to
earlier communication, my lord, holds no field, my
obtain
lord.
instructions. List of next para. Today, Mr. S.K. Talukdar, Learned Standing Council, by placing the order dated this is what? 05/06/2026 passed by the Register of Cooperative Societies submits that a direction has already been given to conduct an inspection under section 88 of Assam Cooperative Societies Act 2007. List of considering above, comma, I'm of the considered view that the grievance raised by the petitioner has been redressed as the inquiry has already been initiated and the direction has been issued to conduct an inspection under section 87 and 88 of the Assam
no,
Cooperative
no,
Societies
only under
Act 2000.
88.
Just wait, you have already initiated, sir.
No,
We have just said initiated.
No, my lord.
See, when you issued a direction
No,
to
Lordship.
produce the records
No, I'm
for
saying
inquiry, that is initiation only.
under the act, my lord. These are two different proceedings, my lord.
You have already initiated. Who is this?
Initiated
Page
under-
57 is which order is this?
That order.
Inquiry officer,
No,
you have
it's-
appointed
Your
inquiry
Lordship will
officer
see,
also.
Your Lordship will see.
Page 57A.
This letter says in.
Please.
supersession- No, my lord, in supersession of the earlier order, your Lordship will kindly see this order. That is why I am saying, my lord.
It is a supersession of earlier 0408. This initiation is 11 August 08.
Because the earlier board is dissolved, now it is under one-man committee. So this initiation is, my lord, afresh. That is why I am submitting, my lord. After inspection, if it arises, my lord.
See, your supersession order is of 0408/2025. We don't know what order is this.
My lord,
Lordship, my humble full submission, Lordship, as per section
It's
41.
okay.
6.
Redress, huh? Redress. Accordingly, the writ petition stands closed with an observation that the respondent authority shall uh, shall complete the inquiry and inspection into the affairs of RSMI's Living Group Housing Cooperative Society Limited in accordance with in accordance with the law. It is needless to observe that if the petitioner is still aggrieved, is at liberty to approach this court again. Writ petition
deeply
stands
obliged. Lord, only one
closed.
observation. I cannot go beyond this instruction, my lord. Only Lordship will record, my lord, as per instruction, inspection is, my lord, initiated. Otherwise, I don't have any instruction with regard to the inquiry. Because, my lord, I would be submitting conflict with
See,
instruction.
if there are law mandates,
Yes.
you go by, that's why I said, as per in accordance with law.
No,
If
your-
it is only inspection, you go for that, nothing will harm.
obliged.
Deeply obliged.
Item number 7. Item number 7.
None appears for the petitioner on call list after 3 weeks.
Item number 9.
Yeah, please, your lordship. Lordship, may kindly pass over the point of.
Why?
Mr. Kyal is on legs.
Same order,
Same order.
same order. That cancellation of GST. You can pass same order.
Same order.
Not Mr.
RS.
RS Mr. Land Counsel for the petitioner. And also had MS
Hussain, Lordship.
R. Hussain.
Mr. Asikel.
Huh?
On behalf of Mr. Asikel. R. Hussain on behalf of Mr. Asikel.
On behalf of Mr.
Mr. SCKR.
SCK Land Standing Counsel. Senior
Special counsel for the-
senior counsel come standing counsel GST. CGST. Same order.
Deeply obliged.
Disposable, same order.
Item number 10.
Only this data of this cancellation and actual data. Two kinds of claim.
There is a case, my lord,
Or give it to Lipat.
the petitioner have applied for NOC for
Hmm.
transfer of land, my lord.
Hmm.
My lord, come to page 42, this, on 27/5/2025.
Ah,
Thereafter, my lord, within 45 days, my lord,
yes, yes.
and my lord, this is a second round litigation, my lord. In the earlier round litigation, my lord, order at page 49.
Hmm.
Here, my lord, directed to file fresh second appeal.
Ah,
And also directed the designated public officer to calculate the penalty, my lord.
page 49.
49 or not, my lord.
Hmm.
49, my lord. And operative part, my lord, page 54.
Hmm.
In view of the aforesaid, it is held that the designated public servant is required to pay penalty as prescribed. The Assam State Commission for Right to Public Services
Shall
shall
deal with amount of penalty
Yes.
so and the rules from there and ensure payments and such excess.
within 30 days, my lord.
Yes, then,
Accordingly, my lord, the petitioner filed the fresh second appeal, my lord, page 55. After filing this fresh second appeal, my lord, page 60, the impugn order, the circle officer has rejected my petition, my lord, for NOC. But the circle officer has no
page,
page 60, my lord, 60,
ah,
60.
NOC,
NOC.
what does it say?
Last line, my lord, 4/12/2025, CO has rejected the application, other rejected as per LRA report. But I have annex LRA report, my lord, page 58. As per report, it is revealed that, my lord, he recommended for allow permission, my lord.
What permission?
NOC, my lord, for NOC.
Heard,
But-
Mr.
But the
Heard, Mr.
But the circle officer, my lord, has no jurisdiction to reject the petition, my lord.
So-
Only district commissioner has the jurisdiction.
Therefore, will issue notice.
My lord,
Heard, Mr.
M. Hussain, my lord.
Emotion, land council, will issue notice. Land council for the petitioner. Next, challenge is made. Challenge made in this writ petition is to the order dated.
4/12/2025,
This is,
in the bottom, my lord. Page 60. No speaking order, my lord.
no, not order, communication dated 04. Can we call it communication or what?
This- And as per, my lord, section-
Status of the
The
status of the
and as per section 21A.
You don't have to, I mean, reject the ground, I mean, reject the
Yes.
petition. You don't have to give the reasons.
difficulty is that it's a hotel. There only the box is very narrow where it's difficult to write down the entire.
Challenge made in the street petition is to the order of rejection that is 04/1/2025 passed by the circle officer
Circle officer.
of what?
Circle officer Dhubri, my lord.
Huh?
Dhubri circle.
What revenue circle?
Dhubri revenue circle.
Dubri. Cannot be Dubri revenue circle.
Yes, my lord.
Where do you get it?
My lord. Page 5, my lord, response number 6.
Dubri revenue circle. Whereby the application for permission, what permission to
For transfer of land.
transfer of land of the petitioner is rejected. You raise a grievance or submit a new appeal.
Yes, my lord, we have already filed appeal, my lord, page 61. This
Okay.
is the first appeal, and page 63,
of-
the second appeal.
What is the land
Land, my lord,
in respect of the, in respect of a plot of land measuring 6.34 lasses covered by DAG number 2068 of 2/2819. Patta number 1223 of village Dubri town, Khas Mahal under Dubri revenue circle, Dubri. Please stuff. Next paragraph. It is the contention of the petitioner that in the earlier round of litigation, this court has directed the petitioner file fresh application before the respondent number 3, which the petitioner had submitted. List of, however, the circle officer, Dubri Revenue Circle, has rejected the petitioner. Has perfunctorily rejected the application of the petitioner. List of. It is contended that the circle officer has no authority under the law to reject the application of petitioner, as the competent authority is the district commissioner
District Commissioner.
of the district commissioner under the law. List of issue notice returnable by 4 weeks. All are represented.
3 to 6.
Huh?
3 to 6. I before 1 and 3.
This is petitioners, huh? Petitioners. 1,
1 and 2 IP.
then 3 to 6. All are represented
No, my
as Mr. A. Bhattacharya, learned standing counsel. Revenue and Disaster Management Department and Mr.
HK Hazarika.
HK has learned state counsel. Enters appearance to accept notice on behalf of all the respondents. No formal notice needs to be served. However, extra copies will be sent. This after 4 weeks.
But if possible, my lord, date may be given.
What day? Let's see.
Obligation.
Not sure. I answer your lordship. I was in court number 10 in item number 7, your lordship. Item number 7.
After 3 weeks.
Lordship, similar pending matters are situated matter are pending in this court, your lordship.
Huh?
Under challenge, I am to say limited prayer. This matter may be taken along with this matter. Item number 4.
Heard, Mr.
K.
Get item 7.
Item 7.
You delete all. Heard, Mr.
K. Mira, your lordship.
No, you just said on the prayer of Mr.
K. Mira, your lordship.
K.
K. Mira, your lordship.
Miraj Mira,
Yes, sir.
learned counsel for the petitioner. List this matter along with.
In this case, notice may be issued, your lordship. In other
But
matters
it's,
also, your lordship kindly peruse this matter. This order.
We'll take after some time.
At 2 p.m. your lordship.
Not 2 p.m. You wait for your turn.
Item number 11.
That is lordship. Lordship, the writ petitioner here is, my lord, is the absolute owner and possessor of a land measuring 3 biga 3 katha, my lord. Covered by tag number 305 old and 485, 486 and 487 new. And patta number is, my lord, 272 old and 182, 1824 and 1825 and 1821 new, my lord. And he has been possessing the said land since 2007, my lord. But suddenly on 3/6/2026, my lord, at about AM, my lord, the respondent number 17, my lord, and then that's a Shivam Transport Private Limited, my lord, represented by one Shankar Saran Das, my lord, enter into my plot of land, my lord.
We don't know. We'll just simply issue nothing. Heard, Mr.
A Mubarak.
Who are you? Are you the owner of the land?
I am the owner of the land.
And why the permission has been given to this corporation?
The permission is taken
Sorry,
another plot of land. By now they have constructed.
How do we know?
Kindly see.
Do you want us to go and inspect and decide which
In this ticket matter, we have filed application, my lord. Before the municipal authority, my lord, we have filed application, our application on 33/2023/26, my lord. But same is pending without.
So according to you, this permission is in respect of your land?
No,
Then-
permission is another land, but construction has been
How
started.
do we know?
That is why, my lord, I have filed application before the GMD and municipality authority, my lord.
Which GMD? Not behalf, you have to tell us. What notice? I don't know.
And I have annexed the trace map also, my lord. Annexer 4, my lord. Lordship kindly look into it.
Heard, Mr.
A Mubarak.
Then why you have prayed for a permission to cancellation of the permission?
That is why, my lord, they have taken permission.
See,
and-
permission is given to some other land, some
and construction has
other
been
plot.
started
And
to-
because, how do we know?
That is why, my lord. And we have filed a complaint before the police authority, but they have not
What
taken
police
any
authority will do?
lordship.
They'll not
And-
decide who is the owner of the land, how the construction is being made.
Lordship.
What's the role of the GMD?
Lordship.
They decide or what? Suppose when there is a dispute, as regard the ownership.
Given permission to some plot of.
Yes,
Whether it's that plot of land,
who will decide then?
that can be decided by the revenue authority.
You approach the revenue authority.
We have also approached the revenue authority, my lord.
Huh?
We have also approached the, and civil suit also pending, my lord.
Then you go there. Then go there.
Civil suit also pending, my lord.
Go
But
there.
There is a, lordship, there is a stay order also, but.
Then go there.
Lordship,
They are not they powerless. Civil courts are the appellate authority.
lordship,
More so when the civil suit is pending.
lordship.
Very unfortunate. Withdraw. Otherwise, you will impose a cost. You are not saying that permission is being given to a particular plot.
Lordship.
Your only grievance is that although permission is given for
Another
plot A,
And construction.
they are concerned. You go there in the civil court. Withdraw.
Lordship, with liberty.
There is no, when the civil suit is pending,
Lordship.
where liberty is here, go approach civil court.
Already, we have.
Go
And-
there.
and
You
they
file
have-
an appropriate application.
Lordship, in the last occasion on 6/3/2000.
Heard, Mr.
They have also manipulated.
Heard,
the
Mr. What's your name?
order.
please?
Mubarak, Lordship.
A. Mubarak, learned counsel for the petitioner. Who submits that he may be allowed to withdraw this writ petition with a liberty to approach the appropriate forum
Lordship.
as the grievance raised. No, please, that's all. Will not say anything.
Lordship.
May have some, it may have some implication if you make an observation. Mr. B.K. Mehdi, learned counsel, state counsel,
178 to 15.
and Mr. M.S. A. Borthakur, learned counsel appearing on behalf of Mr. P. Naik, learned standing counsel, GMD and GMC are present. Accordingly, the writ petition is closed, this petition stands closed on withdrawal.
With liberty. my lord.
Liberty is not with the liberty to approach the appropriate forum.
I have already approached all of the posts. I have already approached them.
With the liberty,
But they have.
with the liberty as prayed for, not appropriate for, as prayed for. Whatever you want to do it, do it.
But in the civil court.
Thank you.
Lordship. in
Thank
the civil
you.
court- Oh, bless.
Heard Mr. A. Buya. Will issue notice? Let us see.
Fine.
Who is appearing? Nobody.
4 and 5.
Okay. Heard Mr. A. Buya, learned counsel for the petitioner. Next, we are aggrieved by the freezing of the bank accounts of the petitioner
Fine.
bearing, what is this?
My lord, bearing number, my lord can.
AC number 3079-22819615
SBI.
with the State Bank of India, Jyoti Kuchi branch, Guwahati. Pursuant to the cybercrime complaint registered by South CEN Crime Police Station, Bangalore City, Karnataka. This petition is instituted. Issue notice returnable by 4 weeks as Mr. B.J. Talukdar, London State Council, enters appearance and accepts notice on behalf. Respondent number?
4 and 5.
4 and 5. No formal notice to serving respectively about this. However, petitioners to take, no, extra copies be so and so. Petitioners to take a stage for service of notice upon respondent number.
One,
Rest of the
two,
respondent.
my lord,
1,
2, 3,
1, 2, 3,
and 5 million.
and 5. Barrister post
No,
as well as legal
not,
person.
my lord, not 5, 6, 7, and 8, my lord.
6, 7, and 8.
Mine.
1, 2, 3, 6, 7, and 8.
6, 7, and 8.
4 and 5 you are.
Mine.
4 and 5 you are.
We have 4.5.
Obliged.
13.
May I please, your lordship?
Yes.
My lord, may kindly see page number 52, your lordship.
Hmm.
The earlier round of litigation, your lordship, our High Court, your lordship, passed a direction, your lordship, to refund the amount in terms of, my lord, got it? Page number 52, my lord.
Hmm.
There is a direction to refund my amounts in terms of final order passed by the Chested Calcutta, your lordship, which was thereafter upheld by the division bench of our High Court, your lordship.
Hmm.
Thereafter, my lord, after this order, a part of payment was done, your lordship. I have mentioned the all in my representation, which is in page number 56, your lordship.
Hmm.
Leaving an outstanding balance, your lordship, a part of payment was done, your lordship.
Hmm.
So this is for the outstanding, this writ petition I have filed for outstanding amount, my lord.
Outstanding amount of what?
Page number 56, your lordship,
Hmm.
81,900, your lordship.
For what?
For my lord, my consignment was seized, your lordship. Two trucks of battle nets were seized, your lordship, by the customs, your lordship.
Hmm.
On the allegation that these were foreign origin, your lordship.
Hmm.
But thereafter I have challenged which was provisionally released, your lordship. Both the trucks were provisionally released to me. I have deposited 15 lakhs and 17 lakhs, your lordship, as a security deposit. Thereafter, I filed appeal in the Chested Calcutta, your lordship, where appeal was allowed. Respondent authorities, the custom authorities was directed to give me consequential relief, your lordship.
Hmm.
But they filed an appeal challenging that order of Chested Calcutta. They filed an appeal in our High Court, your lordship, which was dismissed, your lordship.
Hmm.
Thereafter, again, I have filed a writ petition for the because the both the appeals were dismissed. If it has come to finality, your lordship. So, as a consequential relief, your lordship, I filed the writ petition for refund, your lordship,
Hmm.
for my security deposit and
Hmm.
value of consignment, your lordship, which
Yes.
was allowed. The
Ah.
page 56, page and not 52 is that direction of our High Court, your lordship. After this, your lordship, I have filed an along with this direction, your lordship, I have filed a representation stating all of this, your lordship, to the Shillong custom authorities, and they have made a part of payment, your lordship, leaving an outstanding amount, your lordship.
Yes, if once the order is attained finality,
Lordship.
you have not filed any, you have not taken the to further appeal.
No, Lordship, after division bench dismiss our appeal, we
Then-
file.
Then why you are not refunding?
Lordship, we have refunded 30 lakhs 91,309. Regarding the balance amount of 81,000, Lordship will take instruction, Lordship.
Hmm.
My lord, they issue notice of,
Why it is not ready?
or they may take instruction.
I'll take instructions, Lordship.
Hmm. Next paragraph. Mr. Heard Mr. MS.
SSG, my lord.
SSG, learned counsel for the petitioner. By filing this writ petition, the petitioner prays for a refund of the balance amount of rupees 81,900 on account of the a refund of the your money only.
Yes,
Refund of
Their
the
money.
penalties,
No, Lordship, security deposit.
a security deposit in respect of the seizure of seizure of some items pursuant to the order of this court. List of next para. It is submitted that pursuant to the order of this court, the in respect of seizure of the betel nuts, betel nuts, the pursuant to order of this court, the authorities have refunded the security amount by security amount they refunded an amount of rupees 30 lakhs 91,309. List of the petitioner claims that an amount of rupees 81,900 is still is yet to be refunded. List of considering above, Mr. A.K. Jain, learned counsel, appearing on behalf of Mr. S.C.K.R., and standing counsel, custom is directed to obtain instruction. List matter after 2 weeks. Yes.
Pursuant to my NOC, page 21, the petitioner undertaken construction. Now notice has been served for demolition. Page 21 kindly peruse. This is the NOC, dated 8/2/2026.
Where is the order? Where is the order of notice? What is the notice?
Notice, next page. Next, sir. Page
Page
3.
23.
Yes. And then second notice, page 20.
Heard Mr. P. Manda.
PJ Sahi.
Sorry, PJ Sekhya, learned counsel for the petitioner. Next, for a challenge made in this writ proceedings to the order dated 18/03/2026 and 27/05/2026 was by the Commissioner, Gauhati Municipal Corporation, whereby the petitioner is directed to submit explanation as regards the construction of what?
RCC building.
RCC building. Else the GMC would proceed to demolish the unauthorized construction, at least unauthorized construction list of next para. Mr. PJ Sekhya, learned counsel for the petitioner, while referring to documents at Annexure 4, at page 21, about Annexure 4 to the writ petition submitted by an order dated 08/02/2026, and NOC, and the no objection certificate for construction was issued to the petitioner. Who has issued it?
Well, by the commissioner,
Huh?
by the commissioner.
It doesn't indicate
Does
Who
not
has issued
indicate, but
this?
it is the commissioner.
Pursuant to which the petitioner has proceeded to, has started
I have annexed the photograph.
undertaken construction. Mr. Please stop. Next paragraph. Issue notice returnable by 4 weeks. 3 weeks, huh? You are appearing for all. As Mr. B.K. Medi, London State Council, and Mr. M.S. Aborthakar, London Council, appearing on behalf, enters appearance on exchange notice on behalf of all the respondent. No formal notice need be held. So, our executive be furnished to the Land Council for the respondents. Next paragraph. That's all.
My lord, interim payer, my lord, is required in this case. Otherwise, my lord, they are NOC, my lord. And that is NOC we have constructed. First
Yes,
one,
what do you say?
till then, my lord.
No objection. Considering that the petitioner appears to have been issued no objection certificate for construction by the office of the Gauhati Municipal Corporation by a communication dated 08 by dated 08/02/2026, till the returnable date. No, the impute orders dated so and so, both the orders shall not be given effect.
Briefly obliged.
But you also filed an explanation.
My lord, under their NOC, my lord, we
We
have.
don't know, because that the issuing authority,
notices are
we
silent, my
we are
lord.
not able to locate the issuing authority.
Notices are silent, my lord. What violations, my lord, I
Huh?
have committed while constructing the building?
You file that, you have been given this thing.
Yes.
15.
Obliged.
Before the, anyway.
May I please, my lord?
Yes,
My lord, here I am challenging the order of the respondent number 2, my lord, that is the insurance ombudsman.
insurance ombudsman,
Yes.
where it is?
My lord, it is in page number 40, annex number 5.
40.
Yes, my lord. This is the correction, which was some correction which was made in the order. I'll take your lordship to the relevant portion. Lordship may kindly come to page number 48.
Hmm. Yes.
48, my lord.
Hmm.
This forum, having considered pleadings submitted by the two parties during hearing and on examination of the documentary evidences, issues the following award. Denial of survivable benefit to the complainant on her lapse to pay last premium is unjust and unfair, given to the communication gap that has been between her and the intermediary of the respondent, insurer, and also the fact that the last premium could have easily been adjusted by the respondent insurer from her maturity proceeds. The forum concludes that the complainant is entitled to the survivable benefit subjected to the recovery of the last premium amount along with the delay fee, if any. Accordingly, it is directed that the respondent insurers shall pay the survival benefit of 27,500 rupees per year as per policy condition till the age of 100 years to the complainant, equal to 5.5 interest of the basic sum assured from the due date of 28/3.
Mr.
A. Vishwakarma.
Vishwakarma,
Vishwakarma.
London Council for the petitioner. Next paragraph. By filing this writ petition, the petitioner has put to challenge the award dated 29/03/2026 passed by the insurance ombudsman, whereby the petitioner has been directed to pay the survival benefit of rupees 27,500
Yes.
per year as per policy conditions till the age of 100 years to the respondent number
1.
1.
My lord, my main grievance here is, my lord,
List of,
my main grievance is there are two conditions of policy. Once, if we don't pay the premium, we have certain policy that says that the total amount that she have paid for the last 15 years, that will be given to her, and an accumulated interest amount will be paid to her. That is already paid to her. And accordingly, she went to the ombudsman and she's challenging that the benefit that I'm supposed to get, she's not getting. We approached the ombudsman and we have said that she falls under that category. Though the ombudsman directed us to
he has
adjust the
failed to clear the
Last
premium.
So at the end, my lord, we are agreeing to the fact that we are ready to adjust her last premium. Now the fact is that now she will be availing two benefits. One, once she doesn't pay it, once she pays the premium. Now the problem is, my lord, once we try to execute the order of the ombudsman, she is already getting the benefit, one more benefit that she is already availing right now. So the ombudsman order does not comprise of that, though the facts was already disclosed to the ombudsman. That was our stand before the ombudsman.
You just take this para to her. Para to page 48. 27.
And she took some loans and that was adjusted, that loan amount was also adjusted.
We'll see, we'll see.
Yes, yes.
Issue notice returnable by 4 weeks.
My lord, in page number 16, I have a specific prayer for the stay of the order of the ombudsman here.
We'll see, we'll hear them, we'll consider your prayer on next date.
My lord, just stay may be granted because otherwise my matter become infructuous.
What in process?
Because again, some penalties will be imposed on me, my lord.
No, we'll consider all that.
On the other hand, my lord, we have also intimated to the ombudsman. We asked for the review of the order. They have also given a reply. The provision of review is not there. So that is why we have approached the honorable court. My lord, may kindly see page number 54, my lord. This is the reply from the ombudsman. The last page.
It's okay. Issue notice returnable by 4 weeks.
Till then, my lord,
Till then what?
stay may be granted to the order of the ombudsman. Since I'm challenging that one. Page number
You tell us what's wrong with the award?
Yes, yes. My lord, may kindly come to page number 9, my lord. Page number 9, point number 5. Here, my lord, these are the two conditions of the policy. Page number 9. May I read, my lord? Under full paid up policy, enforced policy or single premium policy on survival to the end of accumulation period and provided premiums for accumulation period have been paid fully, then survival benefit is payable. Now, what is survival benefit? The vested simple reversionary bonus will be payable in one lump sum to the end of selected accumulation period. That is, my lord, in 15 years, an amount of 5 lakhs was accumulated. From that 5 lakhs, whatever profit the LIC have gained, that profit will be given to her. And accordingly, 5.5 of the sum assured will be payable as survival benefit every year till life assured completed 100 years. Now the total amount of 5 lakhs, in that 5 lakhs, 5.5% interest will be paid to her every year till she attains the age of 100 years. Now this is one condition, my lord. Lordship may go to another one, that is under reduced paid up policy. During accumulation period, if the policy becomes paid up, then one survival to the end of accumulation period, reduced paid up sum assured plus bonus will be paid. It means, my lord, the sum assured was 5 lakhs rupees in total. That will be returned to her along with the interest that we have gained from that 5 lakhs for 15 years will be given to her. The other survival benefit will not be given to her. But in case of the petitioners, lordship may kindly see to page number 7, my lord. We have replied this to the ombudsman as well, referring to the whole aspect of the matter. In page number 7, my lord, we have mentioned that there is a this policy has, since she have not paid the last premium, that benefit was given to her. And as she was already having 2 loans against this policy, the saved amount was also reduced after deduction of that amount.
an amount was paid to her. Now, since she have received an amount of 1,37,042 rupees from LIC, after receiving the amount, she went to ombudsman, saying that I am also entitled to get this survival benefit. Now we have explained to the ombudsman that since there are two conditions and she falls under the second condition when she have not paid the premium. Now the ombudsman has directed us there saying that since the last amount can be adjusted, you adjust the amount and whatsoever is the fine required, you can charge that. Now to give the benefit under the second condition, the first condition benefit, whichever she have got it, that has to be given to us. Now after giving that amount, she will be entitled to the second benefit. Now, once we said to the ombudsman that certain correction is required in the order because this aspect has never been, the ombudsman said that we don't have the provision of review. So that there is an eliminative minor. That a policy holder cannot take benefits of the two conditions. Because since we have not paid the premium, now as per the order, we are ready to adjust the amount. Now she should return the back of only 1,34,000 rupees only. Thereafter, she will get the survival benefit 5 lakhs in the interest of 5.5 every year.
We'll consider on the returnable debt. We'll make it 2 weeks. You take this justice service to respond number 1.
Respond.
Issue notice returnable by 2 weeks. Then counsel for the petitioner to take steps for service and notice upon the respondent by dusty mode as well as usual process. Next prayer for list a matter up to 2 weeks. The interim prayer shall be considered on the next returnable date.
Obligation.
It's a benefit to the individual.
Yes.
So we just cannot pass the blanket.
Otherwise, my lord, what happened is like this is a public money.
But we know
Ultimately, LIC.
we know how the insurance company functions.
My lord, we have already given the.
You are very, strict in seeking the premium. When it comes to your turn to pay, you make lots of excuses.
No, my lord, we have already paid her.
Not only I don't know
No,
the
no,
particular incident, we have come across.
Yes, my lord, I agree. But here what happened, my lord, she have got the money. But she should fall under second category, not the first category.
The people has to run and they have to wait for years to get their own due.
I was satisfied.
That is the
the
attitude of the insurance companies all over. We have come across. That's why I was not interested to easily interfere. Yes.
16.
Yes.
Only DRC 01, so there was no so-called notice, my lord. On the basis of form DRC 01, my lord, order was passed and pursuant to which some recovery has been made, my lord. I'm praying for portion of DRC 01 as well as my lord, the order confirming demand, my lord. Order confirming demand as well as from DRC 01, as there was no so-called notice, my lord. Page 19 is the form DRC 01, my lord. Summary of so-called.
Mr.
RS Minister, my lord.
Learned counsel for the petitioner. What is this?
Page 19.
Challenge made in this straight petition is to the summary of so-called notice in the form of GST DRC -01 dated 29/11/2024 for the financial year 2020 to 2021 and the order dated 24/02/2025. Passed by the
Assistant Commissioner, my lord, State Tax.
Assistant Commissioner, State Tax, Gauhati,
Gauhati.
whereby an amount of a demand of rupees 11,16,806.76 is raised on the petitioner list of issue notice returnable by 4 weeks. As Mr. You are appearing for all.
Yes, sir.
B. Chaudhary, learned standing counsel, finance and taxation department, enters appearance, accept notice on behalf of all the rest, no form and notice.
I have an interim prayer also. Lordship, may kindly see page 36, my lord. They have initially recovered proceeding. They have already debited an amount.
Taxpayer, considering that the demand has been raised prima facie without issuance of so-called notice under section
73-1, my lord.
73(1) of the
CGST of the
CGT
KGST.
Act 2007, it is still returnable that it is provided that no coercive action shall be taken against the petitioner.
Deeply obliging, sir.
17.
May I please, Your Lordship?
Yes.
Lordship, your prayer is for releasing of the collateral sale deeds, my lord.
Hmm?
Collateral sale deeds, my lord. So in regard to two loans, my lord, basically, one is midterm loan, one is cash credit loan. So
Hmm.
that was settled out, my lord, in the year 2016.
Hmm.
The bank has settled it in the amount of rupees 32 lakhs, and that was duly paid by the
Hmm.
petitioner company. So thereafter, now they are demanding another 24 lakhs rupees. Though it was settled and already paid, my lord. If your lordship, we will look at page 52.
Hmm.
Yes, that effect bank.
Yes.
My lord, at page 52. So with reference to the above, I am directed to inform you that the bank, after negotiation with the party, is pleased to settle both MT and CC loan accounts of Messrs. Jayashree Mine
Who are-
Products.
Your petitioner has obtained loan.
Yes. Petitioner has obtained loan from the respondent bank, my lord.
Hmm.
Thereafter, so the factory was broke out, means in a burn. So
And then you have repaid.
thereafter the amount.
You have
was-
repaid.
Yes, I have repaid.
So for that, what documents you have submitted?
Then
You are
I have,
seeking for release of the original documents.
yes, my
What
lord,
documents?
sale deeds, my lord. My
Sale
sale deeds are with them, my lord. Equitable mortgage, my lord, it's,
You have paid the entire amount,
my lord.
whatever may be, by your settlement.
Yes, buy of settlement, whatever may be,
Completed.
that I have already paid in the year 2016 itself.
Heard, Mr.
PM the commander.
Learned counsel for the petitioner. Petitioner has obtained a loan from the Assam Cooperative Apex Bank Limited for the purpose of what? Loan is for?
For one is for midterm, one is called midterm loan for the construction, basically construction and establishment of the company, my lord.
Obtain midterm loan
One is one midterm and one CC loan.
and CCS loan from the Assam Cooperative Apex Bank Limited for construction. Construction of what?
My lord, for establishment of the factory.
For establishment of the factory of the petitioner, for which they sold it was submitted. They sold it for the sold it in respect of land covered by DAG number 204 and the Patta number 56, located at village Sarumotiri, Moja, Beltola district, Kamrup Metro, Assam. Was submitted before the said bank. And this is documents is for what?
Which one, my lord?
Why you have to submit the documents?
My lord, the
Say-
collateral,
For collateral.
yes,
Ah,
that was, we have submitted before the bank.
ah,
So it was an equitable mortgage.
ah.
So already settled out that amount and we have
As-
paid
as
that
a,
amount.
Collateral security. List of the petitioner has settled the loan amount with the bank. No, it is the case of the petitioner that the petitioner has already settled the loan amount with the bank. However, they refuse to return the ordinal sale deed oblique documents which was placed as a collateral security. List. Hence, this rate petition for a direction to return the original land documents to the petitioner. Next, for issue notice returnable by 4 weeks. You are appearing for all.
Apex Bank, 1 and 2.
Who else are there? Is Mr.
3 and 4 Reserve Bank, 4 is
Mr.
New India.
Your
1 and 2, Lordship.
your name, please.
Lordship.
Your name.
A Goswami on behalf
A
of.
Goswami, Learned Counsel, appearing on Mr. B. Gogoi.
Ego.
D. Gogoi, Learned Standing Counsel. Some cooperative Apex Bank Limited enters appearance except on behalf of for respondent number 1 and 2. No permits notice need to have extra copies. So it's Learned Counsel, but petitioners to take steps for service of notice of respondents 3, 4, and 5. By arrested for so and so.
My lord, pending disposal status quo may be maintained regarding the land, my lord,
What is status quo?
because the sale deed is with them, my lord. They might alienate, my lord. They might be.
See, once you have cleared the loan, what is the question of alienation?
They are, because they are demanding another
They
more
are
money,
not,
my
they
lord.
are bank, state
They
bank.
are demanding more money, my lord,
State
now,
bank,
after settlement.
state bank. Once you have already settled,
But they are demanding more money. This letter, my lord, letter of recovery, page 70, my lord. My lord,
they are not rogue person. They will not do it.
my lord, may kindly come to page 70, my lord.
Next.
Lordship, there is
Thank
a
you.
similar matter, Lordship, WPC 1179/2020. It may be tagged with this matter, similar matter,
List along with WPC
1179
117 of 20,
20
26,
2020.
2020. Okay. See,
There
Mr.
is no difficulty of tagging, but my lord may look at the page 70, they are demanding more money now. So they might alienate my property, my lord. That is the difficulty.
you take steps, they will not.
My lord, if your lordship didn't pass any order regarding that, they will definitely pass that. Definitely alienate the property.
Hmm?
They are
You are claiming that you have settled.
not only I am claiming, the bank has already clarified it, that the amount was settled and I have paid it.
Then who is asking?
The bank itself asking now. At page 70, that's why I'm at page 70, my lord.
Page 70.
Recovery of outstanding amount lying in the name of company. This has a reference to the discussion had with the Honorable Chairman of our bank on 6/8/2024 on the matter of settlement of dues of your company. In this connection, you are requested to pay the outstanding amount of rupees 24,85,244 only lying in the books of accounts against their company as cash credit accommodation availed from our Tinsukia branch.
So you are challenging this also?
Yes, my lord. And
Then
now further, my lord,
Then
the
you
bank,
add,
my lord, now, yes.
a petitioner challenges the communication dated 06/09/2024. You add in that first para. Whereby issued by the general manager, Assamese Cooperative Apex Bank Limited. Directing the petitioner to pay the outstanding amount of rupees 24,85,244.50 in respect of case credit accommodation availed by the petitioner. Next, the petitioner claims that once since the loan amount, including the case credit accommodation, has already been settled, There is no question of payment of the amount demanded. Mr. You add that, huh?
Lordship, extra copies may furnish to us also.
Hmm? Yes, extra copy.
I'll furnish, my lord. Till then, my lord, status quo may
What is status?
regarding the plot of land, my lord.
You have not shown that you have already cleared it. Where is the statement of the bank that you have cleared all the loan?
Yes, that is at page 52, my lord. At page 52, that is.
Read it.
I will read, my lord. With reference to the above, I am directed to inform you that the bank, after negotiation with the parties, is pleased to settle both MT and CC loan accounts of Messrs. So-and-so, 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 only once and for all to be paid within 31/3/2016. Please ask the party to deposit the settled amount within 31/3/2016 positively, failing which the arrangement of settlement will automatically stand lapsed. So, since the accounts have already been transferred to shadow account, you are therefore asked to close both the accounts. So shadow already, since the accounts have already been transferred to shadow accounts, you are therefore asked to close the accounts, that is MT and CC, in your record and receipt of entire settled amount of rupees 32 lakhs, and thereafter inform the recovery department at head office of the so-and-so, so-and-so, so as to enable them to close the accounts on the records maintained therein. Thereafter, my lord, next page, this all are receipts of paying that 32 lakhs.
So what does it say that it has been completely settled?
What?
What does it indicate? It says that you have to pay, you have to settle.
The amount was settled at 32 lakhs. We have paid 32 lakhs. So
Interim
what
prayer-
remains
interim-
more, my
the
lord?
interim
Now
prayer-
they are demanding more.
Interim prayer of the petitioner shall be considered on the next returnable date.
Much obliged, my lord.
You have not shown anything that it is settled.
Much obliged.
It's a process. You have shown only the process. That's why I was wondering.
My lord, that's what I was asserting, my lord.
You say that was the page 52, which you have just read.
Yes,
Very well.
that was settled out, my lord.
Which you have just read very well. It talks about the settlement. It doesn't say that you have completely, settled the loan. Thereafter, there was some process.
My lord, it completely says
And
that
that to page
these two loans.
59, 62, it talks about some other branch.
No, my lord. This
Tinsukia, where you have availed the loan. Which,
Tinsukia, my lord.
okay.
Tinsukia branch.
Okay, we'll consider.
Much obliged.
Supplementary 47.
May I please, your lordship?
Yes.
My lord, in this petition, basically, my lord, we are challenging an impugned notice. My lord, may straight away can come, my lord, to page 78, annexure, my lord, 9. My lord, this is a order directing that we should remove the alleged unauthorized structure, my lord, which we were, my lord, had been said to be constructed in our land, which in fact is totally not correct, my lord. And before this notice, my lord,
Such a notice be the issue.
Then we'll state this.
Malum.
Where is page?
My lord, page 78, my lord,
Huh?
annexure 9, my lord.
Page?
Page 78, my lord. Annexure 9 is the impugned, my lord. Under section 37, 1 and 2, my lord, 337, 1 and 2 was received by number so and so asking to discontinue the undertaken works of
This is
my lord.
18.3.
My lord, 18.3, thereafter, my lord, we have made appeal before the authority also. My lord, may kindly peruse page 81, annexure 10, appeal dated 25/3/26, my lord, wherein we have stated all details.
Not the appeal, you have to show cause.
No, my lord,
File a reply.
we have already so caused, my lord, against this order.
Where
my
it is?
My lord, we have, what has happened, my lord, before this impugned order, 2 notices have been issued. My lord, maybe I am troubling my lordships with the notice, my lord, is that first notice at page 67, my lord, annexure 5.
Where is the last notice?
Yes, my lord, the last notice is that page, my lord, 78, my lord. my lord, second GMC notice is at page 72, my lord.
You have been directed to show cause.
Yes, yes, my lord, we have already so caused.
Where it is, pursuant to this 18/3/2026,
My lord,
where it is.
My lord, may I kindly peruse
You have
page.
filed directly an appeal.
No, no, my lord, we have against both the notices, my lord, we have responded, we have submitted.
Where it is,
Yes, yes, my lord, is at page 70.
pursuant to this 18/3.
No, no, my lord, this 18.3 is not a so cause, my lord. 18.3 is an order directing removal of the unauthorized. My lord, may I kindly
Okay.
peruse the order, my lord. Under the
To
circumstances.
remove all,
My lord.
pull down this setback.
Exactly, my lord. There is no any structure to be pulled down, my lord. And that too, my lord, basing on a complaint.
Are you
of-
sure?
Yes, yes,
Have
my
you,
lord.
you have not taken any
No, 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 my lord, let. them come
construction?
up, my lord, let them come up with an affidavit, my lord.
Instructions.
Till then, my lord, we may be protected at any time.
Heard
they
Mr.
can come
A.R.
back.
Buya, learned counsel for the petition, learned senior counsel assisted by Mr.
NZ Chaudhary, my lord.
N.J. Chaudhary, learned counsel for the petitioner. You are, how many
Only two, my lord.
petitioners?
My lord.
Next challenge is, challenge made in this reference to the communication dated 18/03/2026 issued by the Commissioner Gauhati Municipal Corporation, whereby the petitioners are directed to petitioners are directed to remove the construction alleged to have been undertaken by the petitioners or to pull down the setback deviation. Pursuant to the notice under notice dated 23/02/2026 on the ground that the petitioners have not submitted any justification
My lord.
to the said notice. You have not,
We have, my lord.
you have
there is
not
a-
submitted.
My lord, we have served the all documents. There
Yes,
there is, I have annexed, my lord.
It is next, but it is the
Fine.
contention of the petitioners. They are in occupation of the they are in contention of the petitioners that the petitioners are having a residential house, public building standing on the petitioner's ancestral land. And there's no fresh construction, any construction
Fine.
undertaken by the petitioner on the said land. Issue notice returnable by 4 weeks. 3 weeks, we'll make it 3 weeks,
Fine.
as Mr. So-and-so, then consent appearing on behalf of interest accept and notice on behalf of respondent. All the respondent,
Lordship,
No,
1, 2, and 3.
1, 2, and 3, no formal notice need be served. And Goswami,
My lord.
1, 2, and 3, 1, 2, 3, and 4, no formal notice need be served in respect of the above respondent, have extra copies. Petitioners to take steps for service of notice upon respondent number 5. Barrister post and such and so. Having considered that the petitioner has filed an appeal against the impugned order so and so and is yet to be disposed of, till the returnable date. The impugned communication dated shall not be given effect to.
Deeply obliged. Deeply.
48. Wait, please, Lord.
Yes. Any order,
My Lord.
any order, a specific order, particular order has been passed.
No, my Lord, yes.
The impugned order at page 138, my lord, without
130.
following the process of law, my lord. 138, my lord, I am a reputed person, my lord. I am running a school. I am the principal of a school. And we have purchased the land. We have got all the documents. And Land Grabbing Act notice has been issued, my lord. Assuming the allegation of Lord complainant is correct, at best there could be a title suit. Because the allegation was on this boundary wall, somebody was digging land for construction of a drain. If a lordship would kindly
Yes.
permit me, Miller.
Yes, yes.
Yes. It's part of the. Milord will kindly come to page number 85, Milord. Initially, what happened in 2020, an FIR was filed by the complainant, Milord. Please come to page 85.
Yes.
82. I mean, page 88, Milord.
Yes.
On top, that the land and the school building of the respondent is situated by the eastern side of the applicant's land. That the applicant, having got information as to digging of drain by some laborer by the side of the applicant's land immediately as there on 17/6/2020. That applicant asked the petitioner, asked the laborer, had engaged them in digging art. They stated to the applicant that they have been engaged by the respondent. Then the applicant asked them to stop their work, stating that they are cutting art on their land. This is the case, Milord. Now
Yes,
this
case has been initiated.
Milord, I'm coming to it, Milord. An
Yes.
FIR was filed where, Milord, from the records it is evident that the OC deputed the case to a particular IO, but Milord, thereafter nothing is evident. It appears, Milord, thereafter the complainant approached the Milord, this tribunal, framed under the, constituted under the Land Grabbing Act. Now, Milord, under the scheme of the Act, first a formal complaint in Form 1 has to be given. Then, based on the complaint, Milord, before taking cognizance of the offence, the Eastern District Judge, Milord, additional district judge or the tribunal will, Milord, call for a report from the circle officer. Thereafter, the question of taking cognizance would come. Here, Milord, the circle officer's report is in my favor. Kindly come to the circle officer's report, Milord. Circle officer's report at page 94. This is the translated version, Milord. Assamese is also there, vernacular. With reference to the session case of the Honorable Additional and District Judge number 1 Kamrup, it is hereby informed that land measuring 147.04R being Dag number 38, Pata number 20, Moza, Modghoria village, Beltola, Moza stands recorded jointly in the name of 37%, including late husband of Srimati A. Kari, namely Nikunja Mozumdar, son of Bharat so-and-so. As per record, 2 bighas of land in Dag number 38 of Patta number 20 of the said Moza and village is found recorded in the name of Gurukul Educational Trust, that is the petitioner. The said land is to be found in the possession of Gurukul Educational Trust, which erected a permanent boundary wall. Said land is found to be in possession of the Gurukul Education Trust being used. Now, this is very important, Milord. During spot investigation of the said Dag, no person by name Srimati Bhavati Mozumdar, wife of late such a complainant, Milord, would be found. An attempt was made to contact the phone number mentioned in the FIR lodged by Bhavati Mozumdar, wife of Nikunja Mozumdar. However, the said phone number belongs to another person. So while lodging the FIR, Milord, a phone number was given, and that phone number doesn't belong to her. And the allegation is, Milord, by the side of her land, somebody is digging to construct a drain, Milord. How is this a case of, Milord? And Milord, where is the procedure followed? The procedure is Form 1 would be there. Based on the Form 1, a report, this is the report, my lord.
Which is in your favor.
Yes. It's an abuse of the process of law, my lord.
Yes, what do you say? Will issue notice?
Yes.
Notice may be issued, but page 90.
And will stay the proceedings?
Yes, my lord. Let them come up with their affidavit,
till
my lord.
next
Let
day.
them
We'll
explain.
see.
No, it's a serious matter,
See,
my lord. Otherwise.
see, this land grabbing is something very. When the report itself says that it's under the possession of the petitioner.
Yes.
If I may submit my.
Yes.
All respect, madam. Page 94
Ha,
is not a report by the cycle officer.
ha.
Let us be very clear on it.
This is what?
This is a communication, my lord, made by the land inspector, land record assistant to the circle officer.
Okay, but where's the report of the circle of?
That is not before us.
Ah.
So that means
is not a part of
the law provides that you have to file in Form 1.
Yes.
And then there should be a report of the circle officer.
Yes.
Then only you can take cognizance.
Yes, now.
We'll
yes.
stay the pattern proceedings
No, my lord.
till next date.
But we will kindly hear, my lord.
Hmm.
This is not a report of the cycle officer.
Ha.
We do not know what is the report of the cycle officer.
You show us where's the circular prison.
Yeah.
Report of.
Milord, may I just interrupt, Milord? My learned friend says this is not of the report of the circle officer. I agree. But this is what was Milord,
yes,
referred,
it's not.
relied upon by the tribunal that I'll show, Milord.
Hmm.
Page number 134. 135. 135. And similar. Urobi Sharma, learned counsel for the petitioner applicant is present today. Today the matter is fixed for report of the circle officer. Learned counsel seeks another opportunity.
Next. Wait.
Huh?
The learned counsel present, the call for reports is received. 22-8.
I'm sorry, Milord, page 136. The learned counsel for the petitioner is present. Call for the report from circle officer is received. However, no application in Form 1 has been filed. Learned counsel for the petitioner seeks another opportunity to file application in so and so. The prayer is allowed now to come up with a so key question.
22.
At 22/8/25.
That is 4-8.
Well, the learned tribunal says IO and report submitted by circle officer. And there is in the record, Milord, there is nothing else. This is the only report.
So rule 16 has to be the.
And the SMS version is also there, Milord. Yes, I also agree. But this is on the basis of this only the circle officer will give the
Page
report.
137 talks about circle officer report.
Yes,
I am to advance argument on the report of the circle officer.
yes.
Where is this circle officer report? There must be some report.
No, Milord, this is the report. There is no other report to our information. If they, while filing their affidavit, let them produce the record, Milord.
After the report,
Yes.
Form 1.
Circle officer report is not there,
Ah.
and lordship will kindly see my lord page 137. Application in Form 1
Yes.
is filed.
Hmm.
The application is there on behalf of the applicant along with few documents. Keep the same tagged with the case record.
Hmm.
Keep learned counsel for the applicant seek some time to advance argument on the report of the circle officer.
Ah.
Meaning thereby that my lord on 10
There is a report.
there is a report. And that report is before a judicial authority
Hmm.
constituted under a statute. Then lordship will kindly see my lord page 138. The last page of the writ petition, my lord. This is the impugn order which has been assailed herein, my lord.
Yes.
See, that is an order dated 16/3/26. If I may quickly read it, my lord. Sri B.K. Sharma, learned counsel for the applicant is present. Argument heard on report of circle officer, meaning thereby that there was a report of circle officer. Having considered the submissions made by the learned counsel for the applicant in the light of application in Form 1, everything is there, and a report submitted by the circle officer, it appears that a prima facie case of land grabbing is made out. So this is to the satisfaction of the court, of the tribunal.
So this can be the gospel's truth.
If I may submit my lord, with all humility. Hence, cognizance is taken against authority of Gurukul Grammar School.
No, I simply were staying the proceedings, further proceedings.
Yes.
You come up with all these things.
Everything, yes.
So, my lord, why is the
See, because this is petitioner is in school.
As a principal of
It's
the
not
school
a,
and in the school.
it's not a school. Land is on the, I mean,
Land
the
is ours.
school is on the land.
Yes.
So it may not be, I mean,
No, my lord,
why
my lord, can you
privacy
see
be,
the land
may not be,
records?
may
Can you
not
see
be
the
a
doc-
case of land grabbing. There
No.
must be little, I
Some,
mean,
there could be some
the-
boundary dispute.
some boundary dispute
Yes.
and some encroachment kind of thing.
Yes.
Maybe there,
That
that cannot be ruled out.
Huh.
But,
It can't be a case of land grabbing, my lord.
land grabbing is something different, is not it?
it is a case of land grabbing.
Had it, no, had it been an individual person and kind of the big shot,
Yes. To that extent.
then we can understand. But this is a school.
Yes.
There's a school on the
My
land,
lord, all the land grabbers of the Gauhati
and
city
the allegation appears
are
to be
dealing with the people in power.
digging of a drain
This
at
petitioner,
the side of the complainant. Is not it?
this petitioner school has a checkered past. And
Okay,
it
we'll
is-
see. We'll consider that.
Yes, Lordship will kindly see there is a PIL pending.
It's okay.
The Honorable Division Bench.
No,
and
that I know.
The Honorable Division Bench.
Election person
Okay.
There is a Honorable.
Personal animals asen.
Okay, we'll see. We'll see.
Yes.
We'll give figure. We'll just, we're not,
Passed by the judicial authority, your lordship, my lord, exercising 226 jurisdiction, my lord.
No, my lord, that is regarding construction of a building. That is nothing to do with land grabbing. I appeared in that case.
yes.
I think my learned friend should have some sense of responsibility before throwing an order at the honorable court. That is an order in the context of no NOC.
Paragraph 6.
That is in the context of no NOC
Paragraph
and
6, my
by
lord.
the GMC and which was regularized.
This school has the habit of cutting hills in a spree. It's a hill cutting spree.
But it's not, here is not the hill cutting.
Yes, it
It's
is
a
there.
digging of drain.
It is there, my lord. Lordship will kindly see paragraph 6, if I may.
Which
read it, my
one?
lord. Paragraph 6.
Which one? This one?
That order.
I'm
Yes.
not concerned.
With respect to the construction of Gurukul Grammar, it has been averred that the site has been visited and it was found that the allegation was correct. The construction poses a potential threat to the nearby residents, especially in view of the site of topography. No permissions also have been obtained. We deem it necessary. In that view of the matter, we direct immediate stoppage of any construction works in Gurukul Grammar Secondary School till the time the matter is finally heard.
So nothing will happen. Because there is an order of the division bench not to do anything. But we're concerned about the land grabbing here, land grabbing case.
Yes. I can
Right.
only plead. I can only plead.
That
with
will not
opportunity.
prejudice anybody,
I can only
I
plead.
suppose.
Yes.
Heard Mr. Ken Chaudhary, learned senior counsel assisted by Mr.
SP Sharma.
S.V. Sharma, learned counsel by the petitioner. Next para. The petitioner challenges the order that is 1603/2026 passed by the addition session judge.
Yes.
Come,
my
what
lord.
is this tribunal? A presiding officer. What do we call it?
Special
But it is the special tribunal.
tribunal under the act.
Special
Yes,
tribunal under, what do you call it?
Assam Prohibition of Land Grabbing Act 2010.
Assam Prohibition of Land Grabbing Act 2010.
No, my lord, Assam land grabbing within bracket prohibition act.
Assam Land Grabbing
Within bracket prohibition.
Act 2010. 2010
My lord.
in sessions LG case number 154 of 2020, whereby a cognizance has been taken against the petitioners on having been found prima facie case of land grabbing. List of next para. It is the contention of one senior counsel for the petitioner although a complaint has been made against the petitioners, the provisions of the land grabbing so and so has not been followed as Form 1 and the report of the circular officer has not been appropriately appreciated before taking cognizance. He submits that the report of the page 94.
Yes,
This is by whom?
this is by Milord.
Uh,
1 second, Milord. Bhumi Hohayok Nam Sakharkari. It's
Land-
actually, Milord, this
Land
is staff
record-
of the office of the
land records inspector of and no officials of the
land records inspector.
land record inspector
Bhumi
of land records, land records assistant. We will say the land records inspector
Land record staff, Milord.
indicates clearly indicates that
It
the
is the circle officer report.
land in question is under the possession of the petitioner. List of next paragraph. Issue notice returnable by 4 weeks. As Mr. You are appearing for all.
So, my lord, I accept notice for R1, my lord.
Then rest,
Yes, my lord, R2 and
Mr. Arbor Pujari, Standing Council,
Revenue Department.
Revenue and Disaster Management Department, and Mr. N. Goswami, Standing State Council for Respondent. Enters appearance exchange notice of all for respondent 1, 2, entry, no formal notice need be served, issued, extra copies, petitioners to take steps for service of notice of respondent number 4 by registered post and so on. Next paragraph. But then this page 37 shows that there is a Form 1. They
Yes,
have already filed the Form 1.
no, Milord. My
And
lord,
there
it
appears
is-
to be a report
No,
of the
Milord,
circle
the
officer.
lordship will see from the orders. First, there has to be a Form 1, then, Milord, the report from the circle officer, then cognizance. Here, what had happened, Milord, on the very first day, statement was taken on note, page 93, Milord. Then, my lord, report was called for. Then at page 135. Milord, entire procedure, end of the day, if a manner is prescribed, it has to be done in that manner.
Record requisited no.
And till Milord 31/5/25, the report of the circle officer was not there, as is evident from page 135, 31/5/25. Records reveal that till that no application in Form 1. That means the very application was not there. Whereas in 2023, Milord, process started.
So what is the procedure prescribed?
Procedure is, Milord, first Form 1 has to be there. The complaint has to be in the Form 1. Then everything will follow. Here, Form 1 was not there till 31/5/25.
Rather, there was a complaint was there
Yes, sir. Oh,
and
without
the
the
Form 1 was filed later on.
Yes, without the form, the Milord report was called for.
From the materials available in the writ petition, my lord, it appears that the procedure has been complied with. That much.
No, see, what do you say? Whether the complaint has to be with the Form 1.
It has to be in the form.
In the Form 1.
It is not there. It is
But when
subsequent.
the matter was taken up,
Huh.
there was no Form 1 not there.
Yes, page
And
93.
the complainant was allowed to file the Form 1.
Yes.
On the date of passing of the interim order, we are concerned with the interim order. That is, my lord,
No,
at the
no,
first.
No, next paragraph. Considering that the complaint was the special tribunal appears to have taken up the matter under the so and so act, on the basis of the complaint, whether there be a complaint under Form
Form 1.
Form
Yes,
1
absolutely. That's the correct position.
and also considering the report by the land records inspector to the circle officer. Comma. Of the considered, no, the comma, till the returnable date, the further proceedings of sessions LG case number 154/2022. 2020 pending before the additional session judge number 1, Kamrup and Gauhati special tribunal.
Special district and session judge.
No, special, what is the designation under the?
Actually, a special tribunal under the act.
Special
Otherwise, he is holding the position of additional district and session
No,
judge.
that's why I would say come special.
Yes,
tribunal.
additional district session, come special tribunal.
This is
Kamrup
special
and
session
Gauhati.
land grabbing case number 154/2020.
No, that I have
Pending
said.
before the special tribunal. That must be.
Is what I said? So and so says shall remain state till returnable date.
Miller.
It will state the proceedings.
Huh?
Still the-
Further proceeding till returnable date.
Seven.
Yes. Voters. Yes. Is it not a subject matter to be challenged before the by way of election petition? Your voters, how many persons? How many petitioners? When was the election? When was the election? 2025, 1 year back. Why? Was there any objection? Huh? Any objection was raised? You are also candidate. Huh? Then who has objected to it? How the local people can object in the nomination? Only the contesting candidates, rival candidate would be. Then how you are affected? Huh? Then it's okay if and one is elected having more than 2 children. What qualification is required? Huh? Class 10 or 12? What is the job of the panchayat data? Ward member? Is it a highly, I mean, one has to be literate? Yes, yes. No, if the law mandates that you should decide, the deputy commissioner or the district commissioner has to decide as regards the qualification. Hmm.
Because that provision is already accepted.
Hmm. That's why I'm asking, it's not a matter to be, I mean, challenged by election petition. No, I'm not, unlike RP Act. Unlike RP Act. Any challenge has been made by a contesting candidate? No, they have challenged the election.
This case, I don't know.
Huh? Why you are so slow? Be little louder. I'm not, my ear is not that as perfect like you. Now, will issue notice. That's a hard Mr. K. Mira, learned counsel for the petitioner. Next para. The petitioner claims to be authors of what panchayat? Rangauti Gau Panchayat in the Hailakandi district of Assam have filed this writ petition challenging the election of respondent number 6. Respondent number 6, namely Mijazur Rahman Majumdar, who has been elected as ward member of ward member of what? Huh? Ward number 4 of Rangoti Gau Panchayat. In the election held in the month of May 2025, on the ground that the respondent number 6 is disqualified to be elected as the ward member under section 1111 2A 2 within bracket 2 bracket close A and bracket close B of Assam Panchayat Act 1994, which mandates that a person having more than 2 children and not possessing minimum education qualification of HSLC is not eligible to contest as Gau Panchayat member. List of next para. Issue notice returnable by 4 weeks. The as Mr. SP Datta, sorry, S Datta, learned standing counsel, PNRD, and Mr. R. Dubey. Huh? Respondent number 4. Enters appearance and accepts notice on behalf of respondent 1, 2, 3, and 4. No form as notice need be served. However, extra copies be furnished to ensure. The learned counsel for the petitioners to take steps for service of notice upon 5 and 6 by registered post as well as by usual process within 3 working days. This after 4 weeks.
Item number 18, order no steps.
Orders on the prayer of Mr. On the prayer of Mr. No, you Mr. M. Bordolai, learned counsel. M. Gotoke, learned counsel. for the petitioner. Further, a week's time is granted to take steps for service of notice. Fresh steps for service of notice upon respondent number 3. Mr. A. Pervez, learned counsel for respondent number. Standing counsel. PNB. What is PNB? Punjab National Bank is present. List after 4 weeks.
Petition item 19. Nineteen.
Non appears for the petition on call. Who is for the estate? Anybody? Health and family. Health. Record someone's name. You just read then. Non appears for the parties on call. Next para. On 04/12/2024. Mr. D. Das, learned counsel for the petitioners. Has made the submissions that the repetition might have become infructuous. And therefore has sought for 4 weeks time to obtain instruction, which was allowed. Christoph, next para. Today, even after lapse of 12, more than 5 months, no instruction is placed as the parties parties are not represented by their councils. Next para. Having considered the nature of the grievance raised in the petition, and also considering that petitioners are not represented, the parties are not represented by the non-represented the parties, and non-represented the parties, it appears that the matter has become infructuous. No, it appears that the petitioners are no longer interested to pursue the matter. Just accordingly, writ petition stands closed.
Petition item.
Yes. Hmm. 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 Are you sure?
It has held lordship at page 604. 604. There, allowing the petition. Number 1, that the contract is undertaken by the SSC by pertaining to legal and their exemption from payment of service tax with under its going sum of mega exemption. The determination made by the respondent of the by issue demand of confirmation in order in order. As contrary to the provisions of the act is not cleared by the Supreme. The entity cannot obtain debit certificates without examining the facts, without coming to a finding that it is very taxable. Simply on the basis of information available in Form 26 AS, debit service tax on the entire amount received on pure expenses. And then what if you are not principally law, order passed by the STD complaint was therefore illegal without judicial consent. Second thing, it has been decided that the entity of to consider the information available in Form 26 AS, whose basis for levy of service tax, but did not consider whether the services rendered by the SSC were exempted from levy of service tax. Since the entity authority did not take into consideration releasing materials which were to consider and to take into consideration factors in materials which were not determined for deciding liability of service tax, the action of entertaining authority was without jurisdiction or in excess of jurisdiction. Action orders and notices issued by the entertaining authority were liable to be refused by the court in its side of founded transferred to the state. Third issue that has been decided on. That for the invocation of provisions of section 73(1), this was for extension of period of limitation, there was necessary to be case. Specified in the provisions of 73. From recital of order in original, no finding was sent the shape of the period by the section 73. For the revenue authorities to there must be findings arrived at the base based on the fact that the SSC has celebrated fraud, illusion and legal misstatement, a contravention of the provisions with intent to evade tax. Such finding was not discreditable for the audit order. Therefore, the assumption of jurisdiction was not wasted on the story, it was unfair. And last, which is fourth point, which is decided. But if you skip was 3-4 lines, the assumption of jurisdiction under section 71 was completely unwarranted as conditions mandated by law and not by the revenue authority, of which the availability of certificate remedy was appropriate case to invoke jurisdiction under Article 26. Interfere with the order in origin, levy of services on SSC by extending the limitation was contrary to the provisions of, and consequently all penalties surcharge and interest were also not leviable. Lordship, sir, exactly same case.
Why you are reading from the head notes?
I did read paragraphs of paragraph 32. First,
You are on the rush. And you have assumed that this court doesn't hear?
what is the case of the SSC?
Yes, what do you say?
As part of procedure, we have followed.
Huh.
And then they have not complied. For that purpose, they issue a notice and the already original liability pass on.
Yes.
So that's
Now, what she's saying, that's why she's rushing to the order of the coordinate bench of this court that it is covered. There's the issue has already been settled. What do you say on that?
subject to the outcome of the proceedings, if I don't know the proceedings, because the issues have been mentioned here. All the cases are not same. All the cases.
That is why I'm asking whether this will cover or not. First of all, if you say that it doesn't cover, we'll hear both sides. So that's why I ask Madam that she might have assumed that this court always rush. Therefore, she will go to the shortcut by referring to the head notes of the judgment. And it took me 2 minutes to locate where you are reading. Because we expect from the judgment itself, not the head notes. No, it's not that. I'm just on thing. So he said it doesn't cover. If he agrees, we'll dispose of. No, I'm asking. Original order has been order in original laws has already been passed. They put to challenge. They are referring this Technocom case. Whether this, according to you, what do you say? If you want, sometime we'll grant you. We'll admit and list for hearing. If you want that, it should be heard. No, that's why I'm asking if. That's why I'm asking the learned. Hmm.
The firstly, the adjudication order which I am referring to at page 51.
Hmm. 51.
I relevant the page 53.
Hmm. 53. Hmm.
From the third party data provided by the IT department for the financial year 14-15, it is appeared that the noticee received consideration for sums and paid required declarations so and so related to the process of service and TDS deduction. However, the noticee did not complete service tax registration. Lordship, this is related to income tax department. This is talking about Form 26 AS, which Lordship has this honorable court has already held only on the basis of Form 26 AS. You cannot levy service tax. This is one of the decision of the Lordship, the coordinate bench. So Lordship, this entire judgment has been passed only on the basis of Form 26 AS for the income tax department. This is my first Lordship similarity of the case. Lordship, thereafter, Lordship, I said about the first point which was decided was I was exempted. Lordship, post Lordship, the exemption which is there. This is Lordship will see that I have annexed the notification at page 68. Thus, page 68 notification makes it absolutely clear at point number 48 and B.
And he has not filed the affidavit also. So no problem is he doesn't agree. Okay, heard MS and Haveli learned counsel for the petitioner. Next paragraph. By referring to the judgment and order dated 09/01/2026 passed by the coordinates bench of this court in the case of Technocom versus Union of India and others, MS Haveli submits that the present writ petition is the issue and the judgment would squarely cover the case of the case of the petitioner in this proceedings. Mr. Next DN Dr. DN Gogoi learned standing counsel CGST submits that he may be granted some time to go through the judgment relied on by the learned counsel for the petitioner. Therefore, prays for listing of the matter after 2 weeks, 3 weeks, 3 weeks, 3 weeks. Prayer for the learned standing counsel so and so is accepted. Accordingly, list this matter after 3 weeks. Interim order passed earlier shall continue. So that is what you want to say that the 20 is not covered. There's a doubt on this. Uh, 21, 33. Yes, do you agree? Okay. Paragraph
32, 38, deals with 1 point.
38, then
Then lordship 57, 40, 46, 40, 46,
ah,
57,
hmm.
71 and 70.
Technocom. Hmm. Hmm. Same earlier judgment. Item. Hmm.
70.
Hmm.
Why it is already passed?
Okay.
That I discussed with the.
Then we'll pass that. Heard. So can it be disposed of by one order? Same order, by common order? Item 21, 22, 23, and 33. Item 21, 22, 33, huh? Sorry. MS and how will learn counsel for the petitioners, and also heard Mr. Dr. B.N. Gogoi, learned standing counsel for respondents. CGST. Next para. Having considered no. ICICI Bank. What is your role?
Yeah, in item. My bank, that. Item number 20. They have attached my bank account.
You are also appearing. 33. Huh? Ah. Just record. No. Just record. In view of the similitude, SMILITUD, of the issues involved in these prohibitions, and has agreed to learn counsel for the parties. This same are taken off. Same are heard analogously and disposed of by this common, we'll say order, not the judgment. Order by this common order. Huh? Then we'll see.
Along with the other.
No, if it is covered, we'll just simply provide the similar relief provided in this Technocom. That's all. Nothing more than nothing less. Huh? Hmm. Who is item 22? Poor men. Poor men. And others are rich. No, it's okay. We'll see. Whatever is similar, we'll just give the
Giving the assessment here.
Hmm. Okay. Okay. Hmm. Hmm. Take. Hmm. No, similar relief which has been provided in Technocom will be provided. Not more, nothing more, nothing less. All right. Yes. Dispose of, huh? 21, 22. आरंभ मोला नहीं निगमन बोल. Yes. Next. Okay. Put it here. Huh? First case of minute here. No. Paragraph of note 32 or Technocom paragraph 57, 71, 72. SS Roy. Yes, SS Roy. What is the matter about? Where's the government lawyer? State council, learned state councils. Or Mr. K.R. Patgiri, learned counsel for the petitioner. Next prayer, on the prayer of who is appearing? Goswami, you appear. Last time the SS Roy appeared. Learned. On the prayer of Mr. Mehdi, BK Mehdi, learned state council for the respondents. Further, 3 weeks time is granted to file affidavit as sought for by Mr. S.S. Roy, learned state council on 17/10/2025. This after 3 weeks.
25.
Yes. Huh. So there's a provision for appeal against this.
Sir, sir. Please take up, please put it up, please be careful about the order. I could request that, I could fundamental. They have to start propose order.
So according to you, there is no record to show that you have been served, although they have issued by registered post. Where is this so-called note? Where is the order? Huh? Order in originally is not there. Hmm. Huh. Page 30. Hmm. Huh.
Dated 7/11/2019, was sent to the following address of the petitioner by Supreme Court under TR number 12, dated 11/11/2019, and the order in original dated But 2022, year number 12. As per the report available in the office, neither the state proposed notice nor the state order in original has been returned by the postal authority. It is stated that they have been delivered today. Doctor, next paragraph is important. Doctor, para 5. The respondent states that the petitioner user did not come to the office, collect the office of so post notice and the order in all. Also, the person or the messenger said to deliver the letter dated 2025 did not come with proper authorization letter from the petitioner. Hence, copies of the so post notice and order in original dated 1/2/2022 were not provided to the messenger. Moreover, it is pertinent to mention here that the recovery notice were sent to the same address as given above. It is beyond belief that the petitioner has received the recovery notice, but not just proposed notice and order in original. Same were sent to the postal. The recovery notice was sent to the same address. They have received the recovery notice, but the order.
But the order they say that they have not.
Johnson. He said, "Malad, it's delivered." We will not confirm it was served, man.
But then how you receive this demand notice? Recovery. Same address. No, that is something different. That is on merit. So far as the service of the order of the copy that were on the whether the order and the so-called notice was served on you. There's an address to a same address was sent to same address.
That's on the situation. What is directed matter? Start the circle, what is to us, and that's what you will listen. But that we will not harm them.
We doing it the same problem one after another. Mhm. So you serve him a copy. Sokos or the order. No. It's short. And Mr. R.S. Mr. and counsel for the petition. And also Mr. K. Jain, and standing counsel. Learned counsel appearing in SCK, learned standing counsel GST. For all the respondents. 225. Which for Union of India? Non-APS disparate service of notice. This was of same order.
26.
Hmm? Then
Power take case cleared account, recover any amount from case cleared account. It's not move matter. You can about cost of interest the bill account. One pay is sir, another pay is to refund the amount matter. So the amount is there recovered is from case cleared account. Can take a lot of time.
what you are saying?
That we challenge the demand itself. Public proceedings which has been initiated by the department. And the petition is not instant, it's a fact. That will be challenged, proceedings. And there is no, what should I be a challenge that part? As far as our recovery is concerned, my plan that account was attached. Was the
Yes. First prayer is that has been removed. And so far as the amount assessment is concerned, you have to file an appeal. No.
They have educated, they cannot, that's why they have revoked matter. Once they cannot attach, they cannot recover also from the account. Once they are admitting it that they cannot attach it, then how they can recover it from that amount? Because yes, account.
But what you have stated in para 6?
I have to appeal, I have to
So the ones that is filed,
file matter. It is not very good thing. Does not need to take one course matter.
no, once we interpret that they don't have the authority to recover, then they have already recovered one.
Yes, they can go for other forms of proceeding.
Where is the prayer for refund? No, it also depends on whether it's recoverable or not.
Yes, they get the one, so you have proceeding matter, but yes, in one account, you have taken loan from the bank, you have not particular from the loan, they are admitting it, that's their wrong. Page 22, this statement does not say that there is a cash credit account first place.
Then why you have revoked it? When you have attached it, when you have revoked? Then when deducted from petitioner's cash credit account, huh?
So that is the case of the department. Because I needs to pay. Now, if it's intending to file an appeal, also there is some, because that has paid with the unpaid court or so that is a normal process. Able to show that people want to see that the department of is incorrect.
Yes, in fact, they have account, they themselves saying malnotation. What they do right, they don't do indirectly man. They cannot attach the bank account and how they can recover from the account man. They are doing indirectly man, that employee to taking the amount from this account man. Now they are saying they are admitting it, I have made the submitted matter, they have recovered because they cannot attach. Then how they can recover man? Question is this man. They cannot attach, how they can recover?
Okay, you file an affidavit. It's the same thing. Go round and then come back. So for a time being, you want to have it. Since they have recovered from the cash credit account, not from the loan account. But you have Heard Mr. R.S. Mr. Alan counsel for the petitioner. Mr. S. Sanjiti, learned counsel for standing counsel in standing counsel income tax department. Further 3 weeks time is granted to file affidavit. Interim order passed, the let's continue. We'll resume at 2 o'clock.
Number 28.
Heard Mr. M.R. Khandekar, learned counsel for the petitioner. Not heard, sorry. Mr. M.R. Khandekar, learned counsel for the petitioner, and Mr. B. Goel, learned standing counsel, Additional Advocate General, have submitted that the grievance of the petitioner has already been redressed. This stuff. Next in view, representatives closed.
Twenty-nine.
Hmm. 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 Ha. Hmm.
Saying that in case it will be put in Zora. Or investigation of that case, like one of the things and things like. Thereafter, we will ask to with the long of the party, but we may do the party, they have find it individually of. They have the affidavit of the civilian statement. In another, was lost in the that about it. That was an investigation of the case, like a one of the. Has come fees. Other even the government offices like say.
Huh? Hmm.
Government offices.
Hmm.
One empire. In 1925.
Hmm.
Of the retail purchase from the citizen. It was purchased on 5 of December 2025, and the incident is on 9.
Hmm. 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 So there is no involvement. Hmm. 30. $49. Hmm.
I mean, that after the. Considering that it bank transaction by using different method by the suspect person from proper investigation of the case and of further transaction withdrawal of money. So that's the is freeze the bank account of all the person involved in the transaction. Paragraph 6 the full investigation after further investigation the investigating officer of not found the involvement of the information with the terms of police station and
Paragraph 4 and 6. No, no, when you are not involved, it's okay. The freezing is on the basis of this FIR only. Criminal case. Okay. His account. Achha.
some fundamental are found from that very as well
Okay.
the direction.
Okay. Okay, when not involved, then heard Mr. will dispose of her. PK Munir, learned counsel for the petitioner, and also heard MS, who is P. Bhattacharya, learned additional advocate general for the state of Arunachal Pradesh, state of Mizoram, for respondent number 3, as well as Mr. M. Sharma, learned standing counsel for respondent number, standing counsel ICICI Bank for respondent number 2. Then, okay. Then you write 1. PK Medi. BK or PK? PK Medi, learned state counsel for respondent number 1. Will dispose of here. Chamber. We'll pass the order in the chamber. Yes, yes.
30,
We'll direct for defreezing of bank account and to operationalize it. Within a week. Can it be done within a week? Within a week. And Mr. J.M.A. Chaudhary. You are for? Your name is not in the respondent side. J.M.A. Chaudhary, learned counsel for the petitioner. Next para. Mr. Huh? It's okay. They'll do it. Mr. J. Hendik, learned counsel for the learned state council, submits that although an affidavit in opposition has been filed on behalf of the state, there are certain mistakes which he would like to rectify. Please, therefore, press for listing of the matter after 3 weeks. It's a rectify 2 weeks. Praise the Lord. List after 2 weeks. 2 weeks. Huh? No urgency. There is no urgency.
31,
Hmm.
Order in P number 15.
Hmm.
Uh,
Hmm.
Some of the banks already released the amount, but the Canada Bank and responded to banks. The Bank of Baroda and Canada Bank not done that.
So,
So on last question, my friend said there is exception not.
This transit of outside, city. Okay.
heard Mr. MS S. Kanungolan counsel for the petitioner. As read for by Mr. M. Sharma, London Standing Counsel. Bank, what is the name of? For respondent number 1, 2, and 3. On the prayer of Mr. M. Sharma, London Standing Counsel for respondent number 1, 2, 3, and 5. 2, 3, 4, and 5. For that 2 weeks time is granted to obtain instruction. 2 weeks. Okay, 2 weeks.
32,
Heard Mr. R. H. Chaudhary, Learned Counsel for the petitioner. It is submitted by MS N. Bora, Learned Standing Counsel, PNR, that the instructions have been received, to which you would like to bring on record by web affidavit. Therefore, fresh for listing on after 3 weeks, prayer is allowed, list after 3 weeks. Huh? So you have approved the action plan. You approve it. You approve it so that writ petition become infructuous. We'll see. Huh? Then you write Mr. T. Hussain. T for what? T for what? Huh? T for chaye. T. Hussain, Learned Counsel for the respondent number 89 is present. 3 weeks.
34,
You are for? Hmm? Heard Mr. A.M. Ahmed, Learned Counsel for the petitioner. Next prayer on the prayer of Mr. MS. Are the Learned Counsel appearing on behalf of Mr. S.S. Roy, Learned CGC? Further 3 weeks time is granted to file affidavit of risk. What's the urgency? Let them file, we'll see.
36,
Yes. Heard Mr. M.H. Ali, Learned Counsel for the petitioner. on the prayer of Mr. HK, SK or HK? Learned State Council for the 3 weeks time is granted to file affidavit of this. Huh? MS, are they for appearing for Mr. SS Roy? Learned CGC, State Council, CGC, and comma MS P dekha, B dekha, Learned Council for respondent number 9, and Mr. A Goswami, Learned Council for respondent number 6 and 11, as well as Mr. You are also. Then you write. Name please. As yeah, do FD for learn standing council for health and a Bhattacharya learn standing council. Hmm? Are present. Hmm? You just write it chronologically, number wise. Yes. Let us see, you've served a copy. Heard Mr. A.R. Buya, learned senior counsel. A.R. Buya, learned senior counsel, assisted by MS. S. Loskar, learned counsel to the petitioners. Mr. Next, H.K. Talukdar, learned state counsel. H.K. sorry, Hazrika, learned H.K. Hazrika, learned counsel, state counsel submits that no extra copies have been served to him, therefore instruction could not be obtained. Mr. MS S. Laskar, learned counsel will respond undertakes to furnish the extra copies, requested extra copies to the learned state council. During the course of the day, today, by Monday, I 15/06/2026 list after 3 weeks accordingly.
Order item 38.
Hmm. Hmm. Notice has not been issued. Hmm. Heard Mr. Learned counsel for the R.H. Chauhan, learned counsel for the petitioner. Next, issue notice to the newly implemented respondent number 5, 6, and 7. List of petitioners to take steps for service of notice upon the respondent number so and so. 5, 6, and 7 by registered post, which by speed post as well as by usual process. Within 3 working days. List after 4 weeks. What I said is notice should returnable by 4 weeks. 3 weeks. I think make it 4 weeks.
39. 39.
Next para. Nobody's there. It's okay. The note appears for the applicant. Next para, office note dated 05/06/2026 reflects that the petitioner has not taken any steps to rectify the steps through rectify the steps to be taken through registered post. No, taken to speed post. Therefore, notice could not be issued by speed post. In view of the council for the petitioners to take steps for necessary steps as directed by this court on 22/10/2025. List the matter after 3 weeks.
40.
Steps you have taken. So no, when did you take the steps? Today. And Mr. B. D. Barua, the constable applicant is present. Present who submits that steps has been taken today. Mr. In view that this matter be listed after 4 weeks. 4 weeks.
42.
Why this is listed today? Amendment cost title. I'm not getting. Can you be little louder? Yeah, once it is struck off, registry has to correct it. That's all. No, there's a problem. This handwritten thing is doesn't support. It doesn't. The in CIS doesn't support the handwritten thing. So you'll have to file the amended cost that. Fresh. Omitting the party who has been okay. A week's time is granted to Mr. J.S. Ahmed learned counsel for the applicant to file amended course title. List after 10 days.
43,
Yes. Hmm. And Mr. D.K. Sharma, learned counsel for the petitioner. Office note dated 09/06/2026 reflects that though ID card although ID card or any unserved notice have been received back, the postal consignment report indicates that notice has been delivered to the addressee. First of, in view of the service of notice upon respondent number 3 is deemed to have been completed. List for admission after 2 weeks. You are for MS H. Barua, learned counsel for respondent number 1 and 2 is present. Interim order passed earlier shall continue.
44,
Yes. 1, 2, 3. Heard Mr. J. Sharma, G or J? J. Sharma, learned counsel for the petitioner. Mr. R. Chakraborty, learned counsel, enters appearance on behalf of respondent 1, 2, and 3, who pressed for and granted, we pressed for 3 weeks' time to file affidavit in opposition. Prayers allowed. List the matter after 3 weeks.
46,
Heard Mr. MHL, learned counsel for the petitioner. Notice since the notice was issued on 01/06/2026, let this matter be listed after 4 weeks. 3 weeks. Mr. You want to file affidavit? What about you? What about you? In the meantime, Mr. J. Hendik, learned state counsel for the state respondents to file the affidavit in opposition. To file affidavit in opposition. Mr. A. Goswami, the standing counsel for PHE is present.
43 order, 50.
Yes. On the prayer, Mr. M. Ali, learned counsel for the petitioner, a week's time is granted to take press steps for service of notice upon respondent number 6 only. 6 only. by dusty mode. List the matter after 4 weeks. MS N Boral, understanding cons health. PNR the N. Who are you? MS? Huh? NB Kaista. Appearing on behalf of respondent, petition, on behalf of Mr. R. Dubey. For respondent number 1, 2, and Mr. N. Goswami. State guns for respondent 4 are present. 3 weeks, yes, 3 weeks then.
51.
Hmm. Hmm. It's okay. It's mistake is E and F. In place of E, it's F. Okay. Or Mr. No objection. RS Mr. Learned Counsel to the applicant and also had Mr. K. Jain Learned Counsel for the respondents. Next paragraph. This is an application praying for correction of the typographical error in the order dated 01/06/2026 passed in WPC number 2789 of 2026. Next paragraph. The writ petition being WPC 2789 of 2026 was disposed of on 01/06/2026, wherein the GST registration bearing number, wherein the registration GST registration number has been wrongly mentioned as 818 AFJ PH 3696 G1 Z6 para 2, in place of GST registration number 18 AE in place of F, para 2. In place of E, difference, change will be EA in place of 18 AE JF so and so and so. Next paragraph. The mistake is F, The correct one is E in place of F. Next paragraph. Having considered that the registration GST registration of the petitioner is inadvertently is wrongly mentioned as so and so at para 2 of the order dated 01/06/2026, I deem it appropriate to allow this application. Accordingly, the GST registration number so and so. The GST registration recorded so and so is correct, stands corrected as GST registration number 18 AE so and so. The order, the instant order shall form part of the order dated 01/06/2026. I stands allowed the disposal. Huh?
You're getting some, they are some orders from the.
Who is there? Who is for the petitioner? What can we do? You should have been little vigilant. No, what prejudice will cause to you? Item 49, AK Mandal Enterprise. You inform them. When it is fixed. Make it read what's there. Any prejudice has been caused to you? Any prejudice has been caused to you? No. Then let it remain.